even closer photograph depicting the picture window, mainly the two impact areas that I marked 1 and 2. Impact 1 is the lower impact on the glass itself. Impact 2 is the higher impact, which is on the window frame.
Now, can you talk about the size of the impact number 1?
Yes, it's a large impact, blew out the wood frame and part of the glass, approximately about the size bigger than a softball. The impact, you can clearly see the broken wood and the fragmentation on the wood, and plus the debris on the porch leads me to believe that it came from the inside towards the outside.
What about number 2?
Number 2, the higher up impact, number 2, is on the frame of the window, the wood frame, and that impact is from the outside going in.
Now, you said that you ultimately got inside the house and did further investigation inside the house, correct?
That is correct.
I'm showing you what's been admitted as People's Proposed Exhibit number 5. Do you recognize what that is?
Yes, I do.
Could you describe what that is, please?
Exhibit 5 is a photograph depicting the interior of the residence at 20524 Leisure, mainly the area closest to the living room window where the impact occurred. There is a small table in front of the blinds, the closed blinds of the living room. There's a lamp. The lamp has a paper shade on it. There's an impact that penetrates both sides of the left side of the lamp and corresponds with the impact on the window, on the blind, the shades, that correspond to the large impact on the outside of the window.
Why is that significant to you?
This is the trajectory. You can see I placed a rod that goes from the previous photograph. You can see the rod sticking out of the hole. The same impact, the same rod that goes through the blinds and through the lampshade.
Now, I'm showing you what's been admitted as People's number 6.
This is a photograph again of the same living room, same window, a little bit farther back into the living room. You can see the door open at the center of the photograph. On the top portion, you can also see the rod of the impact number 2 that comes from the outside towards the inside.
And People's number 7.
This is a photograph of the living room, farther back into the living room near the east wall, where you can see the majority of the living room, the tables that are along the window, the blinds that are closed, the impact, both impacts 1 and 2.
As to impact 1, you said that there's holes in a lamp that's consistent with the holes in the window and the shades, correct?
That is correct.
What does that indicate to you?
The fragmentation, again, as I mentioned, from the exterior on the window, the way the lampshade broke, the papers were bolted, were bent towards the front side, towards the window, same as the exit point on the other side of the lamp that was flared outward, and then the blinds are immediately next to that.
You said you've been in an evidence tech for 11 years.
That is correct.
Is that consistent with any kind of a firing pattern that you're familiar with?
That's how I can determine if an impact came from the outside in or inside out, based on the fragmentation or the flaring of the items that the impact hits.
Can you tell what kind of weapon was used?
Initially, just by looking at this, I cannot tell you. However, I found evidence outside indicating that a shotgun was used. I recovered wadding from a shotgun, and then subsequently, as I searched the interior of the residence in the southeast bedroom, a shotgun was recovered.
Can you tell from looking at those pictures where that shotgun was fired from?
The shotgun initially had to be farther away from the lampshade because the hole of the lampshade, it's a wide one. Once the shotgun is fired, The moment the pellets leave the barrel, they start to flare out and whiten. So the whitening already is evident on the first impact of the lampshade.
How far away is that first impact of the lampshade from the window?
The table is 3 feet from the window. The lamp is at the front end. The lamp is 9 inches from the window itself, so the impact had to be at least 3 feet from the lamp.
Toward the center of the living room, not toward the door, correct?
That is correct.
Now, in those photographs, the blinds are closed, correct?
Yes.
Did you close those blinds?
No, I did not.
And was that the condition that you found the blinds in when you arrived?
When I arrived, the first observation was that the blind from the outside appeared completely closed, not ajar or not slanted. They were completely flat closed. From the inside, it's corresponding to it being completely closed.
And the door, the solid door on that location, is there a window in that door?
On the solid door, I cannot recall off the top of my head, but there is no window. Looking at the exhibit number 3, there is no window on the door.
From the, aside from looking through the hole that was made from the shotgun, is there any way to see from the inside of that house to the outside with those blinds closed?
No.
Nothing further.
Cross-examine.
Good afternoon.
Good afternoon.
Have you had a chance to review your report prior to testifying today?
Yes,
And is your report an accurate and detailed description of your observations that evening?
that is correct.
And how careful did you process the scene?
As careful as any other scene that I process.
So in other words, you processed the scene with a high level of care and attention to detail.
Absolutely.
You found a flashlight on the scene, correct?
Yes.
Where exactly did you find it?
The flashlight is on the sidewalk in front of the residence near the edge of the grass berm.
Was it a typical flashlight that you would find in a store and buy, or was it a distinct flashlight?
You can buy it at the store, but it's the department issue streamlight.
You also processed evidence inside the home, correct?
Yes.
And there was evidence of a shot fired into the home, correct?
Yes.
Specifically, a shot fired into the home that landed into a shampoo bottle in the hallway closet, correct?
That is correct.
Did you see any other weapons in the house?
I did not.
Was the shotgun in or out of its case?
It was in the case, but the case was open.
Did you have to move anything to find the weapon?
No, I did not.
In doing your detailed and thorough examination of the home, did you notice any signs that the home had been burglarized?
I checked the windows, the door locks, the doorknobs. None of them exhibited pry marks or damage or tampered with.
I'm going to repeat my question just to make sure you understand exactly what I've asked you. Is that okay? Were there any signs that the home had been burglarized? Not on just the door locks and the door jambs and the windows. Were there any signs anywhere else?
I did not observe anything that appeared to have been burglarized or ransacked, other than in the living room, the cushions of the couch were on the floor at the time that I arrived.
Did you look at the back door of the home?
Yes.
I'm going to approach you with defendant's proposed exhibit number 4. Does that look like the back door that you observed on the day in question?
I have no idea what door this is. It's just the bottom of a door with a scuff mark at the bottom portion. I cannot tell you which residence this door belongs to or anything.
I understand that. Did you notice that marking on any door in the home, specifically the back door of the home on the day in question when you did your detailed and thorough observation?
I did not.
I'm going to approach you with defendant's proposed exhibit number 5. Does that door look familiar to you?
No, it does not.
Thank you. So during your careful processing of the crime scene, you observed the back door,
Yes,
but you only paid attention to the door locks and the door jambs, correct?
that is correct.
No further questions.
Can you redirect?
No, Your Honor.
Thank you, sir. You may step down.
And at this time, the people have no further witnesses, understanding that we've priorly did People's Exhibit number 1, which was the defendant's statement. I asked to publish the rest of the People's Exhibits to the court, and I have no further witnesses.
Your Honor, at this time, can we have a brief recess?
Yes.
Thank you.
May I approach?
Yes. When we're on the record, I don't.
strong light shining.
You,
I was trying to help you out. The reason the question. Try and really.
are you ready?
Yes, Your Honor.
Okay. People rest.
People rest, Your Honor. Defense counsel is calling a witness. I moved to bind over on Officer Hayes in the complaint on the morning.
At this time, Your Honor, the defense is not calling any witnesses.
Okay. Any argument as to bind over?
Your Honor, we respectfully object to the bind over for multiple reasons. No evidence has been presented to support that anyone in this house on the day in question heard Officer Simmons knock or announce himself or his partner as police officers. Evidence was presented that the occupants of 20524 Leisure made a call for a B&E of an unoccupied dwelling across the street. Evidence was also presented that a 911 call was made from 20524 Leisure about the B&E across the street. However, all evidence was not presented to support that anyone in the home knew or should have known that the officers were going to respond to 20524 Leisure. After all, they were not in an unoccupied dwelling with the green Jaguar in the driveway as it was reported on the 911 call.
Does it make a difference to them?
It absolutely does, Your Honor. Absolutely.
Okay, well, let me ask you this then. Because whether the officers responded to where the call came up or the dwelling that was supposed to be being burglarized, the police were called, and whether it was the police or not, it could have been anybody knocking on the door. Does that necessarily mean that you just start shooting through the window?
There's no evidence that the occupants in the home ever heard anyone knock on the door.
So you just shoot through a window anyway?
Your Honor, there was evidence that this home had 3 days prior been broken into. Door kicked
I
in.
didn't hear anything about that.
Oh, we heard it, Your Honor. We heard it from Officer Simmons. And the court has a stipulated exhibit of an hour-and-a-half interview of Mr. Plummer where that evidence was presented. Mr. Simmons told us twice in that chair that when he received the call from 20524, or the call was made from 20524 Leisure, Mr. Plummer's home, about a B&E across the street in an unoccupied dwelling, and that the home that the call was made from had just been broken into itself. So we know that these folks in this home were fearful. We know that they had just had their home broken into and had no reason to believe police were going to respond to their occupied dwelling. Evidence was presented that the officer didn't do a traditional knock. He did a bam with the bottom of his fist, did a bam with a department. Your Honor, the evidence was presented that Mr. Plummer was home during a home invasion just 3 days before. Neither the defense nor the prosecution dispute any of these facts. This is a very unique case and a situation because there are no disputed facts. The prosecution did not present any argument or evidence that allows a reasonable, conscientious person to believe that Mr. Plummer did not act in self-defense. In fact, the prosecution's evidence that they did present does not even contradict that Mr. Plummer acted in self-defense. The key words or the phrase here to be considered is there enough evidence to infer the defendant acted in self-defense? Now, prosecution is going to lean on an unpublished opinion where the court's dicta is very clear. Whether the defendant acted in self-defense is usually a question reserved for a trier of fact. Key word is usually, meaning that sometimes the issue of self-defense is so clear and or obvious that it would preclude binding the people over. In the case that the prosecution is going to lean on People v. Jackson, the court noted many distinctions that we simply do not have present in this case. In People v. Jackson, the defendant knew or should have known that the four individuals were friends coming to the home and not people attempting to harm the defendant. And there was also testimony in that case that voices were heard outside and that someone announced and identified themselves. We have no such evidence here. We listened to an audio, and it was made moments after this incident. That officer never told anyone back home at the station, I announced myself. We heard him say, and he said that was his voice, we heard him say, he knocked, waited, went to turn away, shot came out. There's no evidence that any of the occupants in the home had reason to believe that the flashlights in the window or that people peeking in or the bam that they heard were the police. There's no evidence of that. The question is not whether the prosecution can simply state contradictory evidence, but whether the evidence actually contradicts self-defense, and it does not. The reason we're here today is to determine if the evidence is sufficient enough to cause a person of ordinary prudence and caution to believe the defendant could be guilty of the charged crimes. Self-defense is a bar against all of the defendant's charges. And I agree with the prosecutor. If the evidence creates a reasonable doubt as to whether the defendant acted in self-defense, then he should be bound over. But here, there's absolutely no doubt that he acted in self-defense. There's nothing in evidence that was presented this afternoon that contradicts Mr. Plummer acted in self-defense. The evidence supporting it is actually overwhelming, not to mention that all of the prosecutor's own evidence clearly shows that as well. Again, this is a rare case, which there are no issues of material fact. The video evidence, the audio evidence, the photos, and testimony all support the assertion that the defendant acted lawfully. And I would ask opposing counsel to point to the disputed facts for a jury to decide that don't support the obvious conclusion that the defendant acted in self-defense. Lastly, it's the prosecution's burden to disprove self-defense in order to prove these charges. It's an unfortunate event. The defense is very sensitive to that. However, no evidence has been presented to show that the defendant's actions were criminal. The chief of police has traveled all around the country encouraging people to defend themselves, and that's exactly what happened here. So for these reasons, we oppose a bind-over and we move to dismiss the charges.
Your Honor, self-defense is a question of fact for the trier of fact. Further, looking at the statute 780.951, there is some language in there suggesting that the self-defense statute doesn't apply when it's police officers that are trying to get into the house. So that's an issue for down the road. What we heard today is that officers are doing their duty. They're volunteering for a run. They go up onto a porch. They knock on the porch. The blinds are closed. The lights are off. At no point before the shot gets fired is there the blinds, anybody looks through the blinds to see who's there, the lights get turned on at all, and then we see that from the evidence technician, the shot is not even fired from the vicinity of the window. You've got to be 3 feet behind the lamp, which is also shot through. This case is not charged this case is not charged assault with intent to murder. This case is not charged any kind of intentional assault in that way. But what this case is charged is reckless discharge of a firearm. It's the people's position, one causing serious injury and one charging just causing injury. That he did.
How do you see reckless discharge?
If you read the language of the count 1, did intentionally discharge a firearm in a facility that he or she knew or had reason to know was a dwelling or potentially occupied structure in reckless disregard for the safety of another. reckless.
That's a little different from reckless discharge. In fact, that's a separate charge in and of itself.
But the
He's
reckless,
charged with discharge in or the building causing serious impairment and discharge in or the building causing injury.
the language of the interior of the charge itself talks about reckless disregard. You're standing in the middle of your living room firing a shotgun through the front window at the door. That is reckless disregard for the people on the other side. It could have been the Girl Scouts, it could have been the mailman, we don't know. In this case, it happens to
Probably
be
not at 11 o'clock at night.
with good parenting, one hopes, right? But, no, but at the same time, you've got people knocking on the door. It's not that they're breaking in, there's a security grate on the door. You don't call out who's there, you don't do anything, you just stand in the middle of your living room and fire a weapon? That's reckless disregard. I'm asking the court to bind over on all the counts.
Okay.
Your Honor, there were armor guard doors on the front and back 3 days prior when that was kicked in. And people gained entry 3 days ago with armor guard doors. So the fact that this family had armor guard steel doors that they thought that they should be safe behind, that was disproven 3 days prior when someone gained entry and moved beyond an armor guard door. Not to mention, it's 11 o'clock at night, close to midnight actually, and you see flashlights going through your window. You hear bam. That's what these occupants heard. They never heard anyone say police. You didn't hear on that audio that these officers even announced themselves as police. It's easy to infer that Mr. Plummer had no reason to believe, one, the police were even going to come to his home. He's not living in an unoccupied dwelling. That was supposed to be across the street. There was no evidence presented that he was even aware that the phone call was made that night. For now.
Now or never. Speak your piece.
Your Honor, self-defense is a bar against the charge, so long as the defendant acted in self-defense.
Okay. That's it. All right. This is a very unfortunate incident all around. One thing is very clear to this court is that I believe the defendant was fearful. He was very, very much afraid. First of all, we know that the police were called, supposedly for a breaking and entering in progress of an unoccupied dwelling across the street. Officer testified that the phone call came from this residence at 20524 Le Jour, and that's why they went to that location. What I find interesting is that it's 11 o'clock at night, it's dark outside. The police officers, they don't come with sirens, they don't come with lights, and the officer explained to us why. They pull past the location to the corner where the car is pretty much out of the view of the house. Officers approach the defendant's location. They're peering through windows, they're flashing flashlights through it. And then Officer Simmons bangs on the door with partial fist, partial metal flashlight, making a lot of noise. He doesn't say police simultaneously. He says it after he bangs on the door. He says it's noisy on the inside. He hears a dog barking. And the defendant presumably is not at the door when he fires the shot. He's standing in the middle of his doorway. By all intended purposes, it sounds like the defendant is afraid. I don't think there's any question about that. The prosecutor's right in that it's not charged with any specific intent crimes, because that would surely fail. And that I don't believe this defendant set out to harm any police officers. I don't believe that. And that's why this is such an unfortunate event. Michigan Jury Instruction 7.15, use of deadly force in self-defense, reads in pertinent part, a person has the right to use force or even take a life to defend himself under certain circumstances. Remember to judge the defendant's conduct according to how the circumstances appeared to him at the time he acted. First, at the time he acted, the defendant must have reasonably believed that he was in danger of being killed, seriously injured, or sexually assaulted. If the defendant's belief was honest and reasonable, he could act immediately to defend himself, even if it turned out later that he was wrong about how much danger he was in. In deciding if the defendant's belief was honest and reasonable, you should consider all the circumstances as they appear to the defendant at the time. Well, I believe the defendant's actions were honest. The question is, were they reasonable? A person may not kill or seriously injure a person just to protect himself against what seems like a threat of only minor injury. The defendant must have been afraid of death, serious physical injury, or sexual assault. Consider all the circumstances, the condition of the people involved, including their relative strength, whether the person was armed with a dangerous weapon or had some other means of injuring the defendant, the nature of the person's attack or threat, whether the defendant knew about any previous violent acts or threats made by the other person. At the time the defendant acted, the defendant must have honestly and reasonably believed that what he did was immediately necessary. Under the law, a person may only use as much force as necessary at the time to protect himself. Consider if the defendant knew of any other ways to protect himself. May also consider the excitement of the moment as it relates to the defendant. So again, I repeat, I believe the defendant honestly believed that he was in danger. The question is whether that belief was reasonable. I don't think there's any dispute as to what the law says about affirmative defense. I mean, about self-defense. Self-defense is an affirmative defense. I was always of the understanding that self-defense was a question of fact to be determined by a trier of fact. A rational trier of fact could in fact believe that the defendant acted reasonably under the circumstances. That because of these prior break-ins, because there was nothing that he could see that showed that these people that came to his door were the police. On the flip side of that, it would be the same situation if it was not the police. It could have been anybody coming to that door. It could have been someone who was trying to burglarize, as someone from that house called the police to address. Or it could have been a family member. It could have been a neighbor. It could have been a child. It could have been anyone. And a rational trier of fact could find that this defendant acted unreasonably in firing a shot without looking to see what he was shooting at, who he was shooting at, to just blindly and aimlessly fire through a window of a home is not reasonable. I think a lot of people's hearts go out for the defendant. For all intended purposes, he seems like a baby. He seems very remorseful. He has a valid argument for self-defense, but that's not for me to decide. That's for a trier of fact to decide. I decide whether or not the people have met their burden of probable cause as it relates to these charges contained in the complaint. And this is a question for a trier effect. And as you know, I'm not the trier effect. So the court, after hearing the testimony of Tyler Simmons, Elijah Hayes, Jacob Moss, and Raymond Diaz, is satisfied that people have met their burden of probable cause as it relates to the charges contained in the complaint in Yellow. The court finds those charges were committed in the city of Detroit, and the court finds probable cause to believe this defendant committed. The defendant will be bound over to Wayne County 3rd Circuit Court, Criminal Division for further proceedings. His arraignment on information date and time will be May 19th, 2017 at 9:00 a.m. His bond will be continued.